Good evening, everyone, and thank you very much for joining myself and Rowan Morton for our evening webinar on TOLATA updates and financial remedy updates. You're very welcome, and thank you for attending. I'm going to be asking Simon to move the slides on as I speak. Turning to the first slide. And this is just a few headline points really in relation to the trends that we're seeing in financial remedies at present. We can expect more judgments to be published. Judges have been asked to aim for 10% of their judgments being published. And that is as part of the drive towards transparency, the movement away from I suppose, what some would call secrecy and what some would call privacy in the family courts. That is in many respects a very good thing. It will be a very good thing for learning, and it will be a very good thing for our ability to advise clients. It's likely to come at a cost in the sense of a challenge to the anonymity, which has very long held sway in the area of financial remedies. In terms of the subjects that I'm going to address you on this evening, I have deliberately chosen updates in financial remedies which are either directly related to or have a good deal of commonality with the TOLATA jurisdiction. And for anyone who attended my update talk in October, I've chosen different cases for this evening precisely because they relate to the TOLATA jurisdiction for those of us who practice in that field and have essentially one foot in TOLATA and one foot in the world of financial remedies. So I'm going to have a look at, with that in mind, the whole business of recent updates on agreements law within financial remedies, TOLATA, and then of course applications under Part 3. So that's the sort of headline points. And moving to the next slide, jumping in at the deep end, so to speak, it's hard to believe that it is in fact 12 years since the Supreme Court's decision in Radmacher and Granantino, which very much changed how the courts approached post-nuptial agreements and prenuptial agreements. And I address first of all this case in the WC and HC case, which was before Mr. Justice Peel earlier this year. In this case, the court considered the weight which ought to be given to a post-nuptial agreement in circumstances where the parties were married, they had 2 children, they led somewhat international lives, mostly in Switzerland, but with the children moving to schools and the wife moving to London. All of the wealth in the family came from the husband's father, who had been generous to the husband prior to the marriage and had continued to be so during the marriage. Prior to the parties separating, the husband proposed that they should enter into a post-nuptial agreement. The wife deeply unhappy about that and made that clear. However, both parties instructed solicitors. There was a travelling draft of an agreement going backwards and forwards with various comments and amendments. There was a whole day of negotiations between solicitors held at the offices of a London solicitor, and ultimately there was a trail of correspondence which resulted in what was not contested to be a set of agreed terms. Those agreed terms were embodied in a document which the wife then refused to sign. Matters proceeded and the parties' marriage did ultimately break down. And the wife said that she should not be held to the terms of the agreement because she had been put under undue pressure in relation to it, and that the circumstances of its inception meant that she shouldn't be held to the terms. The court accepted that she had been under pressure, but essentially said that it wasn't undue pressure. And the court held that in these kind of circumstances, and this I'm sure is a matter that practitioners can attest to, in these kind of circumstances, parties are always under pressure. They're always under a lot of strain. But what the court is looking for is undue pressure such that it would vitiate the agreement which has been reached. It was clear in this case that the wife had a perception that the husband would not allow her to move to London and allow the children to go to their new schools in London in the event that she didn't sign up to the agreement. But the court found that, firstly, she did go to London, absent signing that agreement, and the husband actually waved her and the children off at the airport, and so that perception wasn't ground in reality. The court, of course, also addressed the question of whether or not the absence of a signature on the document was important. The court did hold that the wife could not be formally held to the terms of a document which she hadn't signed, but in establishing whether or not the document was fair and whether or not it should be attributed weight within the Section 25 analysis, the court came to the view that the absence of the signature did not prevent that agreement being essentially upheld. At the end of the day, the wife attained an award which was slightly higher than the strict terms of the agreement would suggest, but considerably less than she had been seeking. So this is a good example of a case post-Radmacher where the agreement has been held to be of great significance. The next case to look at is SC and TC, and this matter was before His Honour Judge Hess again earlier this year. This is a case in which the parties were both in their 50s. They had been married for some number of years, and they had one child who was on the cusp of adulthood. In around 2011, the husband, who had been the primary earner of the family, was diagnosed with Parkinson's disease. In around 2013, in circumstances seemingly of some unhappiness on his part, he visited a prostitute. He came to feel extremely guilty about this and ultimately confessed it to the wife. And the wife responded very negatively. She was extremely cross about this, and she was very unready to forgive him. In fact, she expressed her view very strongly that she felt the marriage was at its end. The husband was extremely anxious that the marriage should continue, however, and at that point the wife suggested that she would be willing to continue with the marriage on the basis of the parties entering into an agreement which bolstered her financial position. And that is how it came to pass that these parties entered into a professionally drafted agreement whereby the husband accepted that the wife should have 80% of all the parties' capital. That was an agreement which he entered into very much against the advice of his solicitor, which was his solicitor's correspondence is included in some passages in the judgment, and it's clear that his solicitor was advising him not to sign the document in despairing terms, but he did so anyway. And he explicitly stated the view that given his reduced life expectancy, there was essentially no point in him having assets at the expense of the wife. The parties continued, but some 6 years later, the marriage did in fact break down. And the wife issued a notice to show cause why the husband should not be kept to the terms of the agreement. By the time the matter came before His Honour Judge Hess, the husband's health had deteriorated further and he did not have litigation capacity. There was no evidence of what his capacity had been at the time he entered into the agreement, but there were certain indicators of his state of mind, which the court held to be of some importance, including that he was extremely depressed and preoccupied with the continuation of the relationship, all of which impacted on the question of whether or not, thinking back to the wording in Radmacher, whether he had a full appreciation of the implications of that agreement. And the view that the court came to was that in fact his state of mind and his vulnerability following on from his health was such that that did impact upon his ability to have full appreciation and therefore detracted from the weight that should be given to the agreement. In addition to that, and unsurprisingly probably to most people listening, the terms of the agreement did not meet his needs. And in fact, in light of his care needs, his needs were significantly north of 50% of the assets, although his open position at trial was that 50% of the assets would be suitable. This is a good example of the court being quite bold in terms of its ability to criticise terms which parties have come to, even though they've been perfectly open about the fact that they may have been limiting their own claims. The final interesting recent case on agreements is this case of Trahani and Lim, which was before Mr. Justice Cohen also earlier this year, and practitioners may also have heard talk of this judgment in relation to coercive and controlling behaviour and the growing jurisprudence around that. Essentially, the parties in this case had been married for 8 years, and they had concluded a post-nuptial settlement between them, after which they had then reconciled their relationship. But subsequent to that, the relationship broke down for a final time. The husband issued a notice to show cause why the wife should not be held to the terms of the agreement, and the wife essentially asserted that the post-nuptial agreement which she had signed up to with legal advice was vitiated by his coercive and controlling conduct towards her, and that in any event it left her short of being able to meet her needs. The court addressed the matters of principle in a very useful way, and the judgment was very clear that coercive and controlling conduct can be essentially a term of undue influence and falls squarely within the existing Edgar criteria to either vitiate or taint an agreement. It's not necessary for there to be, I wonder if we could go back a slide, sorry. It's not necessary for there to be a new category to deal with this, with the growing awareness of this type of behaviour. So that was very much in cases where there is coercive and controlling behaviour. That can be an example of undue pressure. The difficulty for the wife in this case, and we can move on now, sorry, is that the behaviour which the husband exhibited towards the wife was not in this case found by the court to be controlling and coercive. But what the court did find was that the wife, a little like the husband in the previous case, was absolutely desperate to ensure that the marriage continued. And that was one of the reasons that she entered into the agreement, and that concern on her part impaired her judgment. In addition to that, the terms of the agreement did not meet her needs. And so those two factors going hand in hand, the unfairness of the agreement itself, and also the impaired judgment of the wife at the time she entered into it, detracted from the weight that it should be attributed with. And essentially, again, the wife received essentially an uplift on what she would otherwise have received by way of an additional lump sum and a pension sharing order. And it's an example of again, the court interfering with the autonomy of the parties, essentially, in order to meet needs. Moving on, the next slide concerns the well-worn path of Schedule 1, and practitioners will be very familiar indeed with Schedule 1 applications under the Children Act and TOLATA applications essentially going hand in hand. They often travel together, although they are quite different jurisdictions, and in some cases don't make particularly happy travelling companions. This recent case of UD and DN, which is a Court of Appeal decision. It was an appeal against the decision of Mr. Justice Williams. Is a fascinating side note, I suppose, on the Schedule 1 jurisdiction. At first instance, the father in the family, who was the paying party, the father had been found to be a very domineering character, who had essentially sought to use his financial strength as against the mother in order to procure certain behaviours from the children. So he sought to use his financial muscle to get them to do certain things, to undertake certain roles and so on. And the first instance judge clearly felt that they ought to be protected against that and that that was part of his function. He made an order at a time when the children were aged 19 and 14, but when the application had been made when they were 17 and 12. And that order was such that the family home would be settled on them, with the trust period concluding when the younger child of the family had 6 months after the completion of their tertiary education. And that at the conclusion of that trust period, the value of 6.5% of the gross value of the property should go to the children absolutely. Now, the father appealed on 3 grounds, essentially. He argued, firstly, in the Court of Appeal, that an order had to be made prior to the relevant child attaining the age of 18. And had he been right on that, of course, the order in relation to the older child couldn't have been made. Secondly, he said that the court did not have the power to make a property transfer order or a lump sum order to a person who was a child at the time of the order, but who would be over 18 when it took effect. And thirdly, he appealed on the basis that the court was wrong to make an order for the children to receive capital provision when they were adults, when there was no special circumstance as prescribed by Schedule 1 justifying the same. He was only partially successful. Essentially, he failed on the first 2 grounds and he succeeded on the last. The court, of course, and I don't think this needed to go to the Court of Appeal to be established, and the court does have the power to make orders in relation to children who have attained the age of 18 between the date of the application and the date of the order. The court also has powers, and it's very clear on the face of the legislation, to make orders which benefit children over the age of 18, provided that they are in education or training, or where there are special circumstances. But there were no special circumstances here to justify the making of an order beyond that. And there is an interesting discussion in the judgment for those who are interested, or if a case comes up in relation to what special circumstances might constitute. The Court of Appeal stated that the emphasis should not be on vulnerability, but should be on dependency, that the conduct of the paying party, in this case the father, was not relevant, that domestic abuse would likely only be relevant in a situation where it had created an ongoing dependency. And that wealth, significant, enormous, whatever, noticeable wealth, was not in itself likely to be a special circumstance which would justify that either. So in the rare cases where the question about a special circumstance comes up, this is an interesting judgment to look at. If we could move to the next slide for me, please. Finally, this is the last area which I chose because of its relationship to TOLATA. Part 3 applications under the 1984 Act for financial provision after an overseas divorce are another type of application which do sometimes come hand in hand with TOLATA. And as practitioners will know, this is a jurisdiction which has a permission stage and which acts as a filter. It's not intended to be a top-up filter. This case of Al-Duki and Abdullah, which was actually reported at the end of last year, is the only example that I know of a reported case where the grounds of the Part 3 application are the matrimonial home ground, that there was a matrimonial home in England and Wales. So it's quite exciting for that reason. The case concerned was before Mr. Justice Moore, and it concerned a Kuwaiti couple, both Kuwaiti nationals who lived in Kuwait but had spent some, it has to be said, quite limited time living in London. When in Kuwait, the wife had executed a power of attorney in favour of the husband, which enabled him to conduct her affairs. Separately, the parties owned 3 properties in London, which they had periodically lived in. The husband, without the wife's knowledge, used the power of attorney to essentially load the properties with debt to a corporate entity, which during the course of the proceedings, it emerged that he was entitled to. There were proceedings in Kuwait, which ultimately led to the wife receiving very, very little, almost nothing by way of capital provision. And of course, she found herself the joint owner of property in London, which had its equity essentially stripped out. And so what she did was she issued under TOLATA for declaratory relief and orders for sale. And she made a belt and braces application under Part 3 of the 1984 Act using the matrimonial home jurisdiction. It probably won't surprise people listening to know that essentially she did win. Her TOLATA application resulted in the court finding that she was, of course, the joint owner of the property. There were the properties. There was a valid express declaration of trust in relation to all of them. And that was conclusive. The power of attorney, whilst it was valid, never entitled the husband, according to the court in this jurisdiction, to take actions which were contrary to her interests. And so the debts essentially were said by the court not to be enforceable. Under the TOLATA application, the court did come to the view that there was a case for the husband receiving an equitable account for certain mortgage payments that he had made. However, in adjudicating the wife's Part 3 application, which was, of course, on the very narrow basis of the properties having been former matrimonial homes, the court concluded that the money which the wife would have lost by way of an equitable account should be returned to her. So essentially, what the husband had gained with one hand, he lost with the other. And as practitioners will know, the matrimonial home jurisdiction under Part 3 is extremely narrow, and it only enables the court to look at the matrimonial home itself, the property itself, rather than the broader financial circumstances of the parties. And therefore, this is quite an interesting case and a good example of the court being quite imaginative and being bold in what is frankly quite a limited jurisdiction. It's very much bears a full reading. So those are my updates in relation to pure financial remedies as related to and quite similar to TOLATA. And I shall now hand over to Rowan Morton, who is going to address you on more pure TOLATA matters, including detriment and occupation rent. So thank you, Rowan.
Thanks, Hannah. Yes, I'm going to just deal with TOLATA cases, and I practice predominantly in the civil courts. So these are civil cases, but I think equally I have found myself in the family court dealing with them as well, and the same principles and the same cases are cited. So hopefully it will be useful to family practitioners as well. So my first slide is just, there's a lot of text. I just want to make clear that we can send out the slides, and this will be available on our YouTube channel as well for you to revisit. So don't worry about scribbling anything down or reading through it all. I just wanted to point out that the real fundamental difference between sole name cases where only one person's on the title and joint name cases where obviously both people are on the title. The predominant disputes that come past my door, in fact, are sole name cases, because it is so much more difficult for the person that isn't on the title to establish a beneficial interest. And I want to just point out the differences in approach in relation specifically to detriment and detrimental reliance. So I've put 2 cases on here from 2020, and I just want to show how the law seems to have progressed since then. Both of these are sole name cases. The first one is Amin and Amin, and one of the statements made in that judgment won't be surprising. It was detrimental reliance is a requirement for a common intention constructive trust. And I think that's what really we all felt was the way the law had developed. In this case, Mrs. Amin, and you'll notice they both have the same name, but in fact they weren't married under English law. But Mrs. Amin and Mr. Amin had brought a property in joint names, and then it had been transferred around their family. So it had been sold to a cousin, and then some years later they decided to buy it back. For some unknown reason, it was only Mr. Amin's name that was on the title. What's odd about this case is that I call her Mrs. Amin. Mrs. Amin argued that she had acted to her detriment in various different ways that involved working in the family business, giving up a lot of time, buying other things for the family because she had understood this was a joint home. When they separated, in fact, the sons were part of the case as well. And they argued, because they were in occupation, they in fact argued that they could establish a common intention constructive trust because they had been contributing to the mortgage with their father. They'd been living in the property, they'd done improvements, and essentially they treated it as their own. And so sadly for Mrs. Amin, on appeal, the sons and the father were the only people entitled to the beneficial interest because there was no detrimental reliance from Mrs. Amin. The work she'd done in the business and all the other factors were considered to fall far short of what was required for her to establish a beneficial interest, and she was left with nothing. Another sole name case is O'Neill and Holland, again from 2020. This one really does end up with a common sense decision because Miss O'Neill's father, in fact, owned a property that he wanted to transfer to his daughter and her partner. Because Mr. Holland had represented to Miss O'Neill and her father that Miss O'Neill would not be eligible for a mortgage and so couldn't go on the title. On that basis, the evidence was that Miss O'Neill's father had agreed to transfer it into Mr. Holland's sole name. Sadly, her father died, and so when the couple separated, Mr. Holland simply said, well, I'm on the title, it's my property, you don't have a beneficial interest. And while I can see the common sense approach of the Court of Appeal, that in fact they disagreed and they held that a common intention constructive trust was established, the actual causal connection between the detriment, which they said was that she wasn't on the mortgage and wasn't on the title, that is what they established to be the detriment. So they said, well, in fact, the detriment is that she's not on the title and she's not on the mortgage and therefore she succeeds, is rather questionable because there isn't that she wasn't on the mortgage and she wasn't on the title, but that isn't actually detriment that she suffered in reliance upon being told that she would be a part owner of the property. That was just simply a part of what happened. And so there was no financial contribution. There was none of the other usual factors that you would expect. And so it is a rather unusual way to come to the decision, which ultimately I think was the right decision. But it's just an interesting one to look at. And I think if you were to try to apply that, it may be one of those ones that judges feel was only in relation to its own facts. So those are the two sole name cases I just wanted to remind practitioners of. If we move on to the next slide, this is, I'm sure, one that you've all heard if you deal with TOLATA in the civil case field, but Hudson and Hathaway from 2022. Now, this was a joint names case, and so its application in sole names case is obviously yet to be determined. But in this case, they were both on the title, joint tenants. They then became tenants in common equally. And again, it's an unusual case because what happened some years after they had purchased the property and been living there, there was a disaster at the house, a literal disaster. There was an oil spill and the home was completely blighted. And in 2013, having decided to split up, they essentially said that Mr. Hudson was going to keep his pension and his shares, and Miss Hathaway would get the proceeds from the home. In essence, that she would be the 100% beneficial owner of the home. And from 2015, it was Miss Hathaway that paid the mortgage. She took sole responsibility for dealing with the aftermath of the oil spill and all of the litigation that ensued. Rather hopefully, I think, Mr. Hudson in 2019 issued a Part 8 claim for an order for sale and half of the proceeds. Well, the end of the story is that he didn't get them. He appealed, and he argued that Miss Hathaway had not made out detrimental reliance. Now, on that appeal, Miss Hathaway revived her argument, unsuccessful before His Honour Judge Rolton, that she didn't need to prove detrimental reliance. And that was successful before Mr. Justice Kerr. He said that detrimental reliance is not necessary in an ambulatory trust, such as this one, in a domestic consumer context. So what that means is that they were both on the title and they were both joint owners, but there was a change in their common intention that meant Miss Hathaway became 100% beneficial owner. So it's not like a sole name case where somebody is having to establish a constructive trust. This is a change of common intention that creates this ambulatory nature of the trust. So it is, again, it's rather frustrating, because I feel like this is going to be a case that on the one hand very much helps, you would like to think it helps the party who is not on the title establish a beneficial interest by saying, well, detrimental reliance is not required. But what was quite evident in this case is that the judgment of Mr. Justice Kerr did look back at Stack and Dowden and Jones and Kernet, and he said it was striking that none of the majority speeches in those cases mentioned a requirement for detrimental reliance when forming or varying a common intention trust. He went on to say it is all the more striking because the two cases explicitly had the intention of settling and clarifying this area of law. So in that case, it really was an issue of unconscionability. It would be unconscionable for Mr. Hudson to go back on his promise some years earlier that Miss Hathaway had then acted on to her detriment. When reading the facts of the case, one would maybe be surprised by the fact there was an argument about detrimental reliance, bearing in mind she made all the payments going forward, she dealt with the oil spill and the litigation. But in fact, the detriment that His Honour Judge Rolton fixed on at first instance was that she had given up, I think he said, some sort of civil claim for Mr. Hudson's pension and shares. And he found that while they weren't married and there wouldn't have been a claim under the Matrimonial Causes Act, there was a detriment in that she had not pursued him for those assets, which seems an odd detriment to have picked. But in any event, Mr. Justice Kerr decided not to disturb the findings on detriment, saying, well, if I'm wrong about there not being a requirement for detrimental reliance, I would uphold His Honour Judge Rolton's finding that there was detriment in that form. And he didn't trouble himself to go on and consider all the other pleaded detriments, which is possibly a shame, because I think that is the more controversial side of that judgment. So if we can move on from that, I just want to deal with guest and guest. It is a farming case, and it's one that we may not have much application for in our kind of domestic consumer dispute type litigation, but I do think it's important. It was only handed down on the 28th of October, so just less than 2 weeks ago. It's a long-awaited Supreme Court decision, runs to 108 pages. I'm going to deal with it very briefly. In essence, it was a proprietary estoppel case, and I must say, I do, when I come across constructive trust cases, I do sometimes wonder, if I'm brought in at an early stage, whether we should also plead proprietary estoppel. But the remedy has always been quite unsatisfactory. There was certainly a thinking that really the minimum equity to do justice between the parties is what is required, and as a result, remedies are often quite insignificant and not particularly helpful, and certainly don't go beyond what you would obtain in a common intention constructive trust. But hopefully this has shifted things somewhat. It was a comment that had been made over several years by Mr. Guest's parents. One day, son, all this will be yours. He had worked at the farm tirelessly for many years at minimum wage on the basis that he would be inheriting the farm. At first instance, the judge ordered the parents to make an immediate payment of 50% of the business and 40% of the farmland to satisfy their son's expectations of his future inheritance, amounting to some £2.7 million. Now, what's unusual about this case in some respects is that the parents were still alive. They were still on the farm, still a working farm, didn't want to sell it. So understandably, they appealed. The Court of Appeal dismissed their case, and the Supreme Court did not. They looked at the award and felt that there was insufficient discount for the accelerated receipt of this money that the son was going to receive. It was a promise of inheritance, and there were simply too many variables for the Supreme Court to say, well, OK, we're going to wait and we're going to fulfil the promise by some kind of provision for Mr. Guest when his parents die, because, of course, there could be other beneficiaries of their will. There could be a number of things that happen to the farm that would diminish his share. And obviously, a clean break is much preferable in these cases, because if the parents had felt that they wanted to avoid any liability or wanted to do something to the farm against their son's interest, there would be plenty of opportunity for them to do that. So the judgment, it is, as I said, it's very, very long, but there are some really great points that arise out of it that can be applied to proprietary estoppel cases. And it's really about the remedy. So there is no, what they made clear is that, in fact, this idea of valuing the detriment alone is fundamentally wrong and is a misstep. They said that the court firmly reject the theory that the aim of the remedy is detriment based. It is a necessary condition for the equity to arise, but in fact, one has to remedy the unconscionability by satisfying the expectation as much as possible. And while these cases have in the past been refused on the basis of proportionality, what the Supreme Court said is that it would have to be really grossly out of all proportion if the expectation was to be realised. And the example they give at paragraph 76 is that if an elderly lady had promised to leave her house to a carer, if the carer continued to look after her for the rest of her life, but then the elderly lady died the next month, obviously it would be out of all proportion in terms of the expectation and the intention behind the promise. So in this case, Guest and Guest, obviously it was difficult for practical reasons to achieve the expectation. But what they did is they, in fact, gave the parents a choice between two remedies, that they said that the parents could provide an award to their son, but it would be accounted for acceleration. It would be discounted a lot more, or they could elect for a sale now in order to give him the money, or they could live at the farm for the rest of their lives and they could write a trust in their son's favour that would be realised on their death. Now, we don't know which of those has been elected, but it's very unusual to give the parents that choice. And I still feel that if they were permitted to live at the farm for the rest of their lives, there would, of course, be some risk to that inheritance. But as long as the trust was well written, then that is in keeping with the very origins of remedy in proprietary estoppel cases. So I think if you do have a spare few hours, by all means, have a look through the judgment. But what I would say is paragraphs 60 through to 80 are probably where the real kind of crux of the decision comes. Right, if we can just move on, those are the kind of updates on detriment. I want to just go to the next slide and deal very briefly with my final case, which is Ali and Khatib. And this is actually on occupation rent. So this is, again, it's a Court of Appeal case from 2022. And certainly in my practice, I had found that there was a shift towards awarding occupation rent almost as of right in the county court. It was simply a case of, well, if one party has stayed in the property occupying and the other has left and is not occupying, and both are continuing to make the mortgage payments, courts have said, well, there is a right to occupy and the non-occupying party has fairly left and their conduct is reasonable and they should be compensated for that. And one can see the common sense approach of that. However, Ali and Khatib have made clear that there is no presumption that occupation rent will be payable by the occupying party, and there has to be more. And in fact, what they've said is, and this was dealt with in Davis and Jackson, and they've endorsed this approach, is that the focus should be on the occupying party's conduct. So I'll give you some facts about Ali and Khatib. Two sons arguing over the estate of their mother after her death. One son had lived at the property for a number of years. He'd cared for his mother. He had continued to live there with his own family after her death. And there was a will which he believed was the valid will, and it bequeathed the property to him and his family. The other son, who had not had very much to do with his mother or his brother for some number of years, in fact proved that an earlier will was valid, and that will in fact left him as the sole beneficial owner. Now, the important point of this case is that the occupying son had not been aware of any of that during the majority of his occupation, and he had never been asked to move out or to sell the property until this new will and this litigation had begun. And so what the Court of Appeal said is that it's the occupying son's conduct that one must look at to decide, is there anything more about his conduct that justifies an occupation rent, such as delaying a sale, refusing to move out in circumstances where there was an offer on the table for sale, those kind of things, or where there had been some conduct that justified the non-occupying party having to move out elsewhere. Now, I know courts are very reluctant to get into conduct and arguments as to who was to blame for the relationship breaking up. So it really has to be more than that kind of dispute. But certainly worth having a read of that, because it very much is a shift away from, well, if one reconciles that with Rowland and Blades, which you'll remember we discussed at the seminar October last year. Rowland and Blades was a holiday home, and all that Miss Blades did was simply ask Dr. Rowlands not to bring his new partners to the holiday home, which they had only intended to use together at weekends. And in fact, that conduct, that asking him to not bring his new partner to the holiday home, would have therefore been the conduct that the courts are going to be looking for, that justified her having to pay him an occupation rent. Rowland and Blades is very much a case of how you quantify that occupation rent rather than the principles. And then just the final slide, we're still on Ali and Khatib, but it's just an interesting point that came out of that case, that one of the grounds of appeal dealt with the increase in capital value. So where the non-occupying party want a sale of the property and they want an occupation rent, there is an argument to be said, and I've certainly heard it in some of my cases, to say, well, actually, if we had sold when you wanted us to a year ago, we wouldn't have got nearly the amount that we have, because the house has increased in value so much. So in fact, I've done us a favour by obstructing a sale or refusing to move out or whatever it is. And I mean, personally, I think that is a fair point. I've certainly had it run against me, and I've run it myself. And on appeal, that it was said that is not fair to argue that in fact it's completely separate when one looks at whether an occupation rent is required to do justice to the parties, and whether who should benefit from the increase in capital value. But the Court of Appeal rejected that. The judgment of Sarah Asplin endorsed consideration of all the circumstances. So having a look at the benefit that's to be gained by the increase in value, and against the capital repayments, and against any potential occupation rent. So certainly one to look at if you want to try and avoid an occupation rent claim against you, because if the house has increased in value, you can certainly use that to rebut that case. So that's the end of the cases I want to review. So 3 from 2022, but just bearing in mind those 2020 cases on sole name cases, if you are looking at detriment, I think you are still looking to establish detrimental reliance, but bearing in mind, I think that the hurdle has certainly become lower. So a good ones to review as well. Thank you very much for signing into our webinar. As I say, please do get in touch with myself or Hannah if you would like to have a copy of our slides. We can happily send them over to you, or indeed if you've got any problems that you think we could assist you with, please get in touch. Thank you very much and enjoy your Thursday evening. Thank you to Simon and Gavin for helping facilitate.